Thanks for joining us again. Elmari Richter from our family law department. My name is Volker Kruger, by the way. Very important decision I think we need to discuss this morning. I mean, if you look at the legal history of our country, there are a couple of decisions we learn about at university that have far-reaching consequences, and I think this one maybe is right up there.
Yes.
But maybe before we get to the specific case, you can just explain again what the basic options are that you can choose from if you do get married.
Okay, so if you want to get married, you basically have three options. You can get married in community of property, meaning everything you have you will share equally with your spouse.
There's one joint estate.
One joint estate. Debt, assets, everything. The second option is getting married out of community of property without the accrual. So that means what you have is yours, what your husband or wife has, that's theirs. There's no sharing, separate estates, you live your separate lives just by being married.
And you're, for example, not liable for each other's debts.
No,
so
not
if there's
at all.
a financial problem
Yes.
that one of the two spouses runs into, that's separate. So even if your husband or wife is declared insolvent, you're not personally liable for their debts as a general rule.
That's correct. And then the third option is getting married out of community of property with the application of the accrual system, which also means that you're married out of community of property. You are not liable for one another's debt, like you mentioned, but there's a certain sharing that will occur if you pass away or if you get divorced.
Let's say you do get married out of community of property without the accrual system. And let's say the husband works, he builds up a big estate. The wife has to look after the 4 children that they're having together. Never has a chance to work. She supports her husband all along. After 50 years, they get divorced. Can she now not claim from him? In terms of redistribution of his estate, he's got this huge estate, wealthy businessman, and she's got basically nothing, and now they get divorced.
Yeah, well, this is exactly what the case is about. Now, if they got married before 1984, she can apply to court for a redistribution of some of the assets or a certain portion of money or whatever the case may be, saying that, listen, I contributed towards the maintenance of the household, I contributed towards the increase and the growth of his estate, and thereby I'm actually entitled to a redistribution, to a portion of some of the assets, even if we got married out of community of property without the accrual.
That's before 1984.
That's before 1984.
Why is that date so important?
Now, in 1984, 1 November 1984 to be very specific, the accrual actually came into effect with the Matrimonial Property Act that got effected. So with the Matrimonial Property Act, there was now suddenly a third marital regime introduced to our country, being out of community of property with application of the accrual. So if the people who got married before that date never had the option to apply the accrual, so the redistribution was quite an important claim that they can exercise, a remedy available to them because of their work and the contribution that they actually made towards the household. But there will be no sharing if they get divorced. So there was quite a power imbalance. It was to a big disadvantage to the parties whose estate didn't grow. So they made provision, it's in section 7, subsection 3, they made provision for this redistribution, saying that you can apply, the court can exercise its discretion, which is very important, and then if they succeed, a redistribution can take place. But now if you got married after 1984, you actually had the option to get married with the application of the accrual system. So that section in the Divorce Act doesn't make provision for a redistribution for parties who got married after 1984 because they could have elected to apply the accrual system. Now in this specific matter that you mentioned earlier, it's a matter that's been in court now, lots of news articles as well. Like you said, it's quite a big thing, a big judgment that we received. And this matter, the wife and husband got married in 1988, which is a mere 4 years missing that cut-off date of that redistribution remedy. And she said, but listen, I contributed towards the household, I contributed towards the growth of his estate, but never mind what I did. Let's think about the whole public and the community. This is unfair. This is unconstitutional. It infringes my constitutional right. I don't have the same remedy and the same assistance from the law, which I actually are entitled to have in terms of Section 9 of the Constitution.
Just because I married after 1994.
Just because of that date. So they said this limitation that they put on to say that you can only ask for a redistribution if you got married before 1984. That should be unconstitutional. And so in this court case, the court actually dealt with the constitutional validity of this section. Is this limitation actually unconstitutional? And does it infringe constitutional rights? Very interesting matter here.
On the other hand, if you got married after 1984, you had that option to go for the accrual system,
Yes.
which you didn't have before 1984. And I guess that was the thinking behind the legislation and those provisions to say,
Yes.
look, from 1984, we now have the third option as you described. You can go for the accrual system, and if you do, then you don't really need that remedy because then you made your choice. Yeah. But yeah, I don't know. Obviously, we don't want to go into too much detail, but that was one of the arguments.
It was, yes. And a lot of people raised that argument, actually saying, but listen, you signed a contract. You specifically elect to get married out of community of property with the accrual or without the accrual. You made that choice. So a very known principle in our contractual law is that you have to stand by your contract. If you sign a contract and you agreed to enter into that contract, you have to stand by, you have to honor that agreement. And if we now say that this is unconstitutional, this remedy, and it should be available to everyone, then even if you got married out of community of property without the accrual that you elected to do, not to share in anything, to now go to court and say, I want a redistribution of assets, I want to share, it actually means that you're not standing by the agreement that you signed initially. So that was a main argument that was raised.
On the other hand, do all spouses getting married, a lot of them at a young age, really take an informed decision?
That's the problem.
At that stage, you're in love, you just want to get married, you don't really care, maybe don't get proper legal advice, and you sign your contract, and then 50 years later you walk away with nothing after working all your life to build up your husband's estate or your wife's estate. Obviously, it might also be the other way around.
It might,
Let's be careful. So anyway, let's get to the court's decision. The big moment has arrived. What did the court decide?
The court actually said that it is unconstitutional. In today's day and age, how can we discriminate against parties merely on the basis of the date on which they got married? Now you got married 2 years after 1984, whatever. Now you don't have that remedy available. The court said no, it's unfair. It is unconstitutional. There is an infringement on the constitutional rights of a lot of people. So the court said definitely it's unconstitutional. The wording of the section should do away with the limitation of that date, and it should just say that, if you contributed towards your spouse's estate and the growth of the estate, if you contributed towards the maintenance of the household, if you saved your husband a lot of money by taking care of the children, for example, and you can actually prove how your contribution was actually something that was needed for him to grow his estate, then you can apply to court for redistribution, and the court can then exercise its discretion. I think that's very important to also mention. So they said there should be no limitation. Everyone should be able to apply for this redistribution.
So obviously it's still an honest burden of proof. You can't just always claim a portion of the spouse's estate. You've got to prove that those facts are there.
Yes.
So all those many cases that that were relevant for before 1984 would now again be good authority for what the court will look at to exercise their discretion as to whether there should be that redistribution or not.
Yeah, definitely. I 100% agree. It's very important that you have to be able to actually prove that you contributed and you played a big role in the growth of your spouse's estate. And it's not always an easy burden of proof.
Okay, but finally, this is now a decision of the Pretoria High Court, am I right?
It's the
so what is the effect of this? What is the advice to anybody who is now getting divorced, who is maybe married out of committed property without the accrual system?
Well, this is already a precedent that you can follow and that you can apply in your matter. It is important to note that the Constitutional Court should, or while they are still ordered to actually look at this case law and then confirm whether they agree with it. So this court order is not confirmed by the Constitutional Court yet. However, I am of the opinion that it can be applied to pending matters. Obviously, if your matter is finalized, it will have no effect on the matter. This will only take effect as from date on which this order was granted. And
so there's no retrospectivity.
No, it will from here on going
finalize
forward.
The divorce, that's too late.
Done.
Sorry.
Yeah, it's too late. But you can definitely, whilst waiting for the Constitutional Court to actually confirm this order, you can rely on this precedent. And I think the courts will also rely on this precedent, because if they do not rely on this precedent, they are now infringing someone's constitutional right based on case law that we already received. So I think there will be a lot of changes in pending matters. And I think for our clients and for the members of public in future, this will be a big case and something that will be forever discussed. I'm curious to see what the Constitutional Court will say. We have to remember that there is that slight possibility that they will not confirm this order, and then this precedent will fall flat.
Well, I was about to ask for your prediction. You say the slight possibility, so I suppose your prediction is the Constitutional Court will confirm what the High Court said.
I am of the opinion that they will confirm what the High Court said. The arguments raised, it was brilliant arguments. I must admit there is, to my mind, an infringement, although I also think that, you should stand and honor the agreement that you signed. But I think the Constitutional Court will confirm the order, but we'll have to wait and see.